You decided to pursue law.
I did a BSc because I was interested in science and because I had anticipated at that stage, bearing in mind I was a 17-year-old, that I may enter the realm of patent law.
Okay. Oh, but law was already in your mind at the time.
It was.
And thereafter you went for LLB. Did you go to the bar immediately after completing your LLB?
I did not. I lectured as a part-time temporary junior lecturer at Rhodes University before I joined the bar.
What was your area of focus then?
I lectured commercial law to the commercial law students, and I lectured the course known as business structures to the LLB students.
And you've now been practicing as an advocate for how long?
I believe it'll be in the region of 13 years this year.
Is it a smooth sail? Are there challenges of a discriminatory nature because you're a woman? Very briefly, what is the situation at the bar for you?
It was challenging in the beginning. When I commenced my practice, I practiced for about 9-10 months before I received my first brief from an instructing attorney.
9-10.
9-10 months, yes. I was filling my time by doing criminal trials on the instructions of the Justice Centre, and my certain senior male colleagues at the bar also provided me with deviling. But yes, to build up a civil practice took a long time. It did.
Is it strong now?
It is, yes, I'm happy to say it is.
For how long, all in all, have you acted as a judge?
I've acted for approximately 8 or 9 months as a judge.
Tell us why you believe you should be the one to be appointed.
I'm very passionate about our Constitution. It's a source of great pride for me that I am a citizen of a country that has a constitution that is regarded internationally as being one of the most progressive in the world. And it would be a privilege for me to serve on the bench and to play an active role in upholding and protecting that constitution.
And what would you say, if you were to boast a bit, makes you stand out? Why do you think it would be an error if you were not to be the one recommended for appointment? What would the institution, what would the system be losing out on?
Chief Justice, I do believe I am intelligent, hardworking and diligent. Some of the comments made in respect of my application have indicated that the judgments I have written are well reasoned and detailed in that reasoning. And so I do believe I write well, clearly and logically. So yes, those are the unseen, if I can put it that way, attributes I would bring to the bench.
And before I let go of you, you were the Assistant Secretary of the bar, Assistant Honorary Secretary of the bar at some stage.
Yes, I was.
Was it for a year or longer?
If I recall correctly, I was Assistant Honorary Secretary for a year, and then I became Honorary Secretary.
Then you became Honorary Secretary. And for how long were you Honorary Secretary of the bar?
I think it was almost a year.
Yes. Anything you want to say before I ask the JP to put some questions to you in support of your candidature?
Well, I spoke about the unseen attributes I would bring to the bench, but there is also one obvious attribute that I would bring. The bench in the Eastern Cape Division as a whole is comprised of only 37.5% women And so, unfortunately, in the Eastern Cape, we are lagging behind in terms of gender representativity, and that is another aspect to which I could contribute in a meaningful way.
On average, how long do you keep judgments reserved?
Well, I haven't calculated an average, but I have not delivered a judgment more than 3 months after I've reserved it.
Thank you. JP?
Thank you, CJ. I wish to greet the commissioners that I have not had the opportunity to greet during the tea break. Good morning, Council.
Good morning, Judge President.
I wish to thank you for availing yourself. And I would like to start off by saying, indeed, you've honored each and every opportunity I availed you to act. And indeed, you
Sorry, JP, just bring it closer, please, and on your left-hand side.
Thank you. You've honored appointments. Every time I asked you to act, you've availed yourself, even in the midst of a busy practice, and you've handed down judgments timeously. You've been practicing for 13 years. Have you considered taking silk?
I have been urged by certain colleagues to consider taking silk. The taking of silk, however, is a consideration that doesn't simply involve whether or not one can take silk. The manner in which my practice has developed is such that I am presently and have been for a little while now receiving silk-type briefs. But my attorneys have been quite candid and frank with me. They have told me that they have briefed me in those kinds of matters because they believe I am competent to handle them, but also because their clients cannot afford the services of senior counsel. And my concern is that if I take silk, I may stop receiving some of those briefs. So there is an economic consideration as well.
Thank you. Nothing precludes you from leading a junior, is there?
No.
Yes.
And I have in the past requested juniors, unfortunately also on the basis of cost. My attorneys have turned that request down.
Is there no dispensation whereby counsel will even share their fee?
Yes, there is. I haven't yet done that, but what I have done is I have, and I do fairly frequently, provide the juniors at the bar with deviling work.
Thank you. In his nomination letter, Advocate Sandy says, and I quote it, "Your appointment would not tamper with the constitutional imperative of balancing gender and demographic representation on the bench in the Eastern Cape." Do you support that view?
I do insofar as the gender point is concerned. As I mentioned earlier, the Eastern Cape bench is lagging behind in gender representativity insofar as demographics are concerned. If we take the starting point being that 50% of our population is women, the gender representativity of women on the bench in the Eastern Cape does fall way below that.
Yes. My question is a context. Right now at Bisho, we've got 2 white females
Yes.
and 1 black male, African male. If a white female were to be appointed, there would be 3 females versus 1 black male. And then in Port Elizabeth, we do not have a black female, do we?
No, we do not.
Then my last question relates to case flow management, something you know I'm very passionate about.
Yes.
I once requested some of my colleagues, as part of the workshopping we do in the various centers, to workshop case flow management in Grahamstown. That was on the 2nd of April 2019. And in a memorandum they generated after the workshop, they reported to me as follows. Certain attendees from the bar and sidebar indicated their respectful view that the civil role in Grahamstown worked exceptionally well, as it is, and that all was already under control. Would you associate yourself with that?
Judge President, my understanding of case flow management is to expedite matters and to have them concluded as swiftly and as efficiently as possible. My experience as both counsel and as an acting judge is that there are a large number of trial matters that are postponed on the morning of that trial because one or other or both of the parties are not trial ready. And so from that point of view, I would disagree with that statement. I understand that the practitioners feel that because in the Grahamstown High Court you can obtain a date relatively speedily that they don't think there is a problem. But constant postponements increase the cost of matters and they decrease the efficiency with which they are finalized. And that, in my view, is a problem.
Yes. And would you agree with me that case flow management need not only be applied to civil trials, but it's extended to opposed applications as well, or to applications generally?
Definitely.
In your view, how should case flow management be given effect to in the scenario of application proceedings?
Well, within application proceedings, one can ascertain fairly easily from going through the papers and seeing what has been filed and what has not, whether or not the matter is ripe for hearing. If, for example, no heads of argument have been filed by either party, then it's highly unlikely that the matter would proceed on the hearing date. The parties then should be requested to indicate whether or not they intend filing heads of argument, because, of course, heads of argument can be filed late. They just have to be accompanied by an application for condonation. And then once it is ascertained whether or not they intend filing heads of argument, the hearing readiness of the matter can be determined, and a decision can be made well in advance of the date of hearing as to whether or not the matter should remain on the roll. Because, of course, if it remains on the roll, the judge presiding over that opposed motion court is obligated to read the papers. If the matter then doesn't proceed, seldom will the same judge preside over the matter when it is enrolled at a later date, and so it means a different judge will have to read the papers. And it can result in a great deal of inefficiency and duplicated work.
All right, let's deal with that. From an administrative point of view, would you agree that it is important for the judge president at the level of the checkpoint that you referred to determine the readiness of the matters, so that if none is going to proceed, then that particular judge is allocated some other work during the
Yes.
ensuing week?
Yes, I would absolutely agree that is the job of the head of the court, to ensure that the judges are sent and allocated to duties as efficiently as possible so that as much as possible can be dealt with.
Last question. Are you aware that in Grahamstown, especially among practitioners, there's a few, maybe let me not say few, let me just say there are some who still resist case flow management? Something which I would say is different from what is obtaining in the other centers within the division.
Yes, I am aware that there is that view in certain quarters,
Yes.
which is a pity, because in my view, if case flow management is to achieve its goals and if it is to function at optimum efficiency, the legal practitioners actually have to buy in and cooperate and enter into case flow management in the spirit it is intended.
And you can place it on record at this commission that Grahamstown was the last center to jump into case flow management.
Yes, it was.
Yes. The attitude is that why fix that which is not broken? You've heard that terminology before.
Yes, I have.
Thank you, CJ.
Thank you, JP. Premier?
Thank you very much, CJ. Thanks so much. The JP has almost covered me on technical questions. Just wanted to check from you, Council, that I've seen that you have almost applied in every divisions that were out, except Mthatha. Is there any reason why probably you didn't consider going from Mthatha as well?
There is. At present, my home base is in Makhanda, formerly Grahamstown. And the Bisho High Court and the Port Elizabeth High Court are equidistant, just about, from my home base. And so were I to be appointed in either Bisho or Port Elizabeth, I would then reside, in the case of Bisho, in East London, and in the case of Port Elizabeth, in Port Elizabeth during the week, and travel back over weekends when I am able to do so. So it was basically a question of being able to commute.
Through you, CJ, once more. The follow-up one, just your understanding on something that we have just raised earlier on, the protection of the Constitution versus serving our people. What is your understanding of that? I thought I wanted to make a follow-up on the question that CJ raised earlier on your jurisprudential philosophy, shifting from science into law, and what was this? And I thought CJ was asking the same question. If you probably can a little bit elaborate more on that as well.
On my shift from science into law?
Yeah.
Well, I wouldn't say I necessarily shifted from science into law. When I did my BSc, I majored in chemistry and legal theory. So I did law throughout my BSc, as I said, because I had intended, when I made the decision to do a BSc LLB, to go into patent law. So I didn't really shift from science to law. Law was always my intended profession. As regards the protection of the Constitution, as you said, versus serving the people, in my view, when we protect and uphold the Constitution, we serve the people of the Republic of South Africa.
Thank you, Premier. Commissioner Nyambi?
Thank you, CJ. Morning, Advocate.
Morning.
Why do you think it's crucial for the bench to reflect the race and the gender composition of the country?
Well, it is mandated by the Constitution that judicial officers, insofar as possible, be appointed so as to ensure that the bench reflects the racial and gender demographics of our country. The Constitution does require that in express terms, and as we know, the Constitution is the supreme law of our land. But in addition, in order for our courts to function efficiently and effectively and for the system to work, the people of the Republic must respect our courts and their orders. And it's very difficult to ask of the people of the Republic to respect the orders of our courts when those orders are being made almost exclusively, as they were in the past, by white men who in no way represent the gender or racial demographic of the country.
If you can share with us your understanding of the doctrine of separation of powers.
The doctrine of separation of powers holds that the three branches of government, the executive, legislature, and judiciary, are separate. And it's a very important doctrine. In the matter of Bernstein versus Bester, Ackerman J, in writing for the Constitutional Court, held that the right of access to the courts as contained in the Constitution promotes the separation of powers doctrine, particularly insofar as the separation of the judiciary from the other arms of government is concerned, and that is of vital importance because one of the judiciary's functions is to uphold the rule of law, which is, of course, a fundamental and foundational value of our Constitution. So the separation of powers doctrine is very important for upholding the rule of law. And we've seen it operate in many judgments from the Constitutional Court.
Thanks, Advocate. Thanks, CJ.
Thank you so much, Honorable Nyambi. Commissioner Norman?
Thank you, Chief Justice. Good morning, Ms. Bed.
Good morning.
Yes. I read two of your judgments, the one that deals with the Gray Mudlia matter and the Nkola matter. Can we just debate first the one that deals with the Mudlia matter? In terms of which rule of the uniform rules did you review and set aside the decision that you reviewed and set aside?
The review was a so-called legality review, and so the applicant did not launch it specifically in terms of Rule 53. The applicant forewent its right to call for the record, so it was not a Rule 53 review. It was launched as an ordinary but urgent opposed application.
No, but are you allowed to review a decision in the manner in which you did?
I believe I am, yes.
On what basis then did you, because you didn't have any records, you didn't have any indications of what amounts this lawyer was charging the municipality, what informed the decision then, what informed you to say that decision had to be reviewed and set aside because you didn't have the benefit of the mechanism that Rule 53 brings?
Well, it's not correct to say I didn't have any record. I did have the transcribed record of the council proceedings at which the decision was debated and then the resolution taken. So I did have the full record of that. In addition, I had an affidavit from the director of the firm setting out categorically that the firm had never charged 100 million rands in fees in either a single 1 year, 3 year, or 5 year period, and that was stated under oath. In addition to that, the municipalities opposing in its opposing papers, it distanced itself from the statement that 100 million had been charged. And so on those bases, I was able to determine the matter.
But you still did not have a record that would have given you a statement of account issued by the lawyer to the municipality, the payments made by the municipality, and what was outstanding. You're only relying on the affidavit of the lawyer, am I correct?
Which is evidence under oath, which was not disputed, yes.
Yes, I understand that. But the benefit of the Rule 53 record would have given you all those details. Do you agree?
Well, I'm not certain that that would have been contained within the Rule 53 record, because the Rule 53 record relates predominantly to the documentary information and the documents available to those taking the resolution and making the decision. And at no stage were any documents relating to fees charged by the firm placed before the municipal council.
Chief Justice, if I may just, because it's still the same, it relates to the same case. The other basis, the basis upon which you found that decision had to be set aside and reviewed was that if you allowed the termination of that relationship in terms of the SLA that had been signed by the firm of attorneys and the municipality, that would have led to irregular and wasteful expenditure.
That came in the argument relating to urgency.
Yes, but I just want to understand, does a court, if a client says to an attorney, I am terminating your services, is there room for a court to say, you can't terminate because that might lead to irregular expenditure because now you have to employ another firm of attorneys?
In respect of an ordinary litigant, not. But in respect of the municipality, I found that I could. For starters, the termination was not the exercise of a private contractual right conferred upon the municipality by the SLA. In addition, the municipalities are not in the same position as ordinary litigants. They have to go through the public procurement process before they can appoint an attorney. So unlike an ordinary litigant cannot appoint any attorney they choose. They must go through the public procurement process. So there are distinguishing features, and I do believe I did set those out in the judgment.
Yes, but the attorney provides legal advice, and client says your fees are exorbitant, whether they've proved that or not, and I want to terminate your contract. Does a court have room to say you can't terminate your mandate?
On the basis set out in my judgment in those particular facts, I believe yes.
Thank you. The second judgment, CJ, if you would allow me, is the Nkola judgment.
Yes.
There you make the point in that judgment, if I may just direct you to the exact area. Where there's agreement that relates to, it, you seem to suggest actually that this particular applicant waived his right, that they may not execute against against movables, but may directly execute against immovable. I hope I'm not misquoting you. I just want to find the relevant sentence. Sorry, if you could just. I beg your pardon, Chair. Yes, I think this is where I want to direct you, paragraph 21, where you say, I disagree with the approach adopted by Appellant's Counsel. In my view, the appellant on 9 May 2014, in settlement of the application in which an order declaring his immovable property executable was sought, undertook to make payment of the judgment debt in installments and agreed that should he fail to make payment of these installments, the respondent was entitled without further notice to him to execute. Plainly, this could only contemplate execution against the appellant's immovable property, as this was precisely the relief sought in the application. The appellant thus by agreement forfeited his right to claim that the respondent should have sought to execute against his movable incorporated property first. What is the legal basis for that conclusion?
My basis with the terms of the settlement agreement that the respondent entered into.
I just want to understand, can one agree or waive a constitutional right that one has? We're dealing with immovable property. Can a person say, I owe you money, don't worry about my movables. Even if I have a Porsche that you can sell to settle your debt, don't worry about it. Just go for my house. You understand that to be acceptable?
A person can waive a constitutional right as long as it is not an inalienable one. The right to property, in my view, is not an inalienable constitutional right.
So, in other words, whether as a court, because you were sitting as a court, you were not bothered to understand who resided in those homes. Were those residential properties? You were not bothered as to whether they were children, elderly people, and if those homes were executed, whether this person will in fact have a home left. You're saying to me that, to the commission, you were not really concerned about those things.
No, that's not what I'm saying at all. This judgment was concurred in by two other permanently sitting judges as well. It was an appeal full bench judgment. This judgment was taken on appeal to the Supreme Court of Appeal, and that appeal was dismissed. So the Supreme Court of Appeal upheld the ultimate decision. It was not a case of not being concerned about who resided in the properties, plural, at all. That had been dealt with, and it had been dealt with in the judgment of the court a quo. I was dealing with the appeal, and so I was dealing with the points raised in the notice of appeal.
Yes. Now, are you saying, I'm not, those other judges who concurred, I'm not suggesting that they were wrong. I'm talking about you. I want to understand your reasoning. Because we're dealing with the agreement that was there. I wanted to understand, if a party has an agreement and that party says, don't worry about movables, let's deal with my immovables. Are you saying that that inquiry would not have been necessary because you would have been satisfied that that's what he agreed to?
Well, the other context of this judgment is that it was decided before the new Rule 46 capital A came into effect relating to execution against immovable property. And I don't believe that one can simply ignore those inquiries at all. They are relevant and of great importance. But as against that, one must balance that an individual can contractually waive certain rights. It will, of course, involve a balancing act. And in the course of that balancing act, whether or not the property is residential, whether or not it is occupied by a woman-headed household, how many children live there, and all of those sorts of factors would have to be considered.
But this judgment doesn't deal with those factors.
No,
am I
the
right?
court à quo dealt with those factors in its judgment.
But the appeal
In the same
court,
matter.
I'm talking about the judgment that you're
Yes,
talking about.
no, my judgment doesn't deal with those
Thank you.
matters.
Thank you, Chief Justice.
Thank you, Commissioner Norman. JP Mlambo.
Good afternoon, Advocate Bird.
Good afternoon.
I just want to get comfort that we should accept your statement that you're ready to be appointed to the High Court. So I'll ask you two questions. I can't ask you a lot of questions. One question is, looking at your application or questionnaire, paragraph 9.2, you've listed the periods when you've acted, starting from 2016 to this year, 2019. I've counted 34 weeks. Would I be correct?
Yes.
That translates to just under 4 terms
Yes.
cumulatively. I want to get a sense, what did you do in your acting stints? What work did you do? Did you do opposed motions? Did you act in the urgent court? I've just heard now you sat in a full court, but I just want to get that comfort. What did you do?
I did preside over both criminal and civil trials. I was duty judge, and so I presided over both the unopposed and the opposed motion court, and dealt with urgent applications. And I was also formed part of the bench dealing with civil and criminal appeals.
So is that the whole gauntlet of what permanent judges do? What about reviews? I mean, the Eastern Cape has a lot of magisterial districts under it.
Yes. Sorry, I omitted to mention I have handled reviews from the magistrates' courts, both special and automatic reviews.
The bail appeals?
Yes, I did have bail appeals.
So you did everything,
I believe I did, yes.
right? Now, which of these work areas gave you an appeal?
Sorry.
Like an uphill, which ones did you find difficult for you to handle?
Well, the urgent applications, there's always a degree of pressure because they have to be dealt with as soon as possible. And so one doesn't always necessarily have as much time as one would like to deal with the matter. So those can be pressurized.
The urgent court? that is,
Yes.
Yeah. Well, in your opposed motions, I mean, in the norm, or normally, how many would you get per week if you are in that court?
Ordinarily anywhere between 3 and I had as many as 8.
In 1 week?
Yes.
And how long did it take you to write those judgments?
Well, I've never delivered a judgment more than 3 months after it was reserved, but generally I would say between 3 and 8 weeks.
Are you not one of those who have that track record when you act, and when you become permanent, you start reserving for longer? Because that's the phenomenon we have as JPs.
No, I definitely make every effort to deliver my judgments as expeditiously as possible.
And have you delivered extempore judgments, especially when you're in the urgent court?
Yes, I have.
Right. Would you deliver extempore judgments in any other work area other than the urgent court?
It would depend upon the nature of the subject matter. I could, for example, see myself perhaps delivering an extempore judgment in relation to issues of costs, that sort of thing. But when the matter becomes more complicated, I no, I would generally prefer to reserve the judgment.
Thank you. One last question, CJ. I see you list commercial work as some of the work you did. Now, you're not a silk, so you were not led. So were you the sole counsel in those matters? And how did you get those instructions? And let me just tell you why. Those instructions don't go to black counsel. So that I'm asking you, how did you get those instructions in the commercial matters?
That's a very interesting question. A lot of the instructions in commercial matters that I received came to me in circumstances in which a senior colleague was unavailable to take on the matter and recommended a number of counsel at the bar, me being one of them. I've also been instructed in commercial matters by attorneys to whom I was introduced by my pupil mentor. And I suppose they decided to give me a try.
Okay, thank you very much. Thank you, CJ.
Thank you, JP. And maybe I should just come here using my dear colleague as an example. I was using my fingers to count, JP. You asked 9 questions. And Commissioner Norman was not particularly restrictive. I think at least 6 questions. So colleagues, please just identify those sharp questions that you need to ask. I know there will be a need maybe for follow-up. There may be a need also for a third question, but let's just try to regulate it properly. Thank you. Minister?
Thank you, Chief Justice. Good afternoon.
Good afternoon, Minister.
Thank you. I just want to start where the JP ended. Have you ever wondered why your other black colleagues don't get the same kind of commercial instructions that come to your table? And if you did, is there anything that you have ever done to help the situation?
I have wondered about that. I have had 2 black pupils, Ms. Baninzi and Mr. Ntlukwana. Whilst they were my pupils, I actively took them around and introduced them to the attorneys that had instructed me in matters. After they successfully completed their pupillage, I reminded my instructing attorneys that they had successfully completed their pupillage. And I'm pleased to say that as a result of that, both of them did, when they started their practice, receive briefs for the unopposed motion courts, which is where most junior counsel at the Grahamstown bar start. And they were briefed in default judgment matters where they were acting for the banks, so they did receive commercial matters.
Given this background and that context of particularly women practicing advocates struggling to access this kind of commercial work, and the various reports that comes from the affirmative action reports, which indicates that there is a favor of white women by mostly private companies, even on senior position. Do you think if it's yourself and another African black female capable for this position, who do you think for us as the JSC should appoint to advance transformation?
The black woman.
Thank you.
Honorable Dodovo? Okay, Honorable Moiman?
Thank you, Chief Justice. One of your judgments dealt with the fees must fall protest.
Yes.
Did your consideration of academic freedom and university autonomy played a role in dismissing the application that was brought by the Concerned Association of Parents and others at that university?
It did. I believe I did say in that judgment that the university should have the freedom to deal with the protests and the nature of the protests as it saw fit, and that for me to grant the specific performance would be an improper exercise of my discretion.
The last one is the Nelson Mandela Bay Metropolitan University, municipality. Kindly elaborate on the referral to the exercise of public power by an organ of state as contribution to good governance. Thank you.
Well, the rule of law tells us that all exercises of public power may not exceed the bounds of that power conferred upon the particular organ of state by the Constitution, and it must also be a decision which is rational. The exercise of the public power must be rational. In other words, the decision must be rationally connected to the purpose for which the power is given. And when that is done, when decisions do conform with those two requirements, good governance can be achieved, because organs of state will then be making rational as opposed to arbitrary decisions, and will exercise their public powers within the boundaries of the Constitution.
Thank you. Thank you, Chief Justice.
Thank you so much. Thank you so much, sir. Prof?
Thank you, CJ. Good day, Advocate Beard.
Good afternoon.
Oh, good afternoon. Right. I hope you have read the comments by Nadel and the Society of Law Teachers,
Yes, I have.
which they are not very happy about your appointment. In fact, they don't support your appointment to the bench. So in response to their lack of support, how would you counter the issues that they have raised in their letter that they have submitted? Particularly if you take Judge Sandy's support, that is nothing more concrete, which gives evidence or which is indicative of your commitment to the constitutional values, because it's nothing. It's more of a sentimental approach to your support, other than being you committed to the Constitution, particularly on transformation. Thank you.
Yes, thank you. Well, you're quite correct, Nadel. Do not support my appointment. There is a factual inaccuracy, however, in Nadel's comment. They make the statement that there is no black female judge at the Grahamstown High Court. That is incorrect. There is Judge Bisho. In addition, in my view, Nadel's comments place no weight whatsoever upon the fact that I am a woman, and so could assist in transformation insofar as gender representativity is concerned.
Are you done, Prof? Thank you. Commissioner Mpofu?
Thank you. Good morning, Advocate Beard. Good
afternoon.
Sorry. Yes. Well, my first question relates to the matter of concerned associations of parents and so on versus the university. Would you agree with my assessment that that judgment was rather conservative in the sense of, or maybe I should ask this differently, what informed your decision to make the order against university in the light of the fees must fall protests that at least are widely seen as legitimate?
I didn't make an order against the university.
the specific performance in favor of the university.
I didn't make an order of specific performance in favour of the university either. I'm sorry, I'm not certain I'm understanding your question.
What informed your decision to dismiss the application that was made in regard to the fees must fall protest
Okay.
and the so-called concerned parents?
In that application, the concerned parents had brought the application because what had happened was the university had elected to close its doors for a period of time because of the protests. The university was concerned that it couldn't guarantee the safety of its staff and students, and so it closed. The concerned parents then brought this application in which they wanted me to direct that the university reopen its doors within 48 hours of the order having been given. And they categorized the relief they saw as specific performance. A court has a discretion as to whether or not to grant specific performance. The university pointed out in its opposing papers that if I were to grant the order that the concerned parents sought, for starters, it would operate in perpetuity. So it wasn't actually, the relief sought wasn't actually only linked to the fees must fall protests. If there were other protests that happened later on, or there was some other reason that caused the university to close its doors, someone would have been able to rely on the order had I made it. So it would operate in perpetuity, which is an incredibly harsh and heavy order to make. And secondly, the university also pointed out that it was doing everything it could to continue with the academic program as quickly and expeditiously as it could. And it set out in full the steps it was taking. In my view, that militated against the exercise of my discretion, particularly where the university was concerned that it could not guarantee the safety of its staff and its students if it were ordered to reopen its main campuses and commence with its academic activities as per normal.
Okay, so is your answer then that in those circumstances it was not a conservative approach?
I don't believe it was a conservative approach.
Okay, the second question is, you mentioned, did I hear you correctly that you've actually never led a junior?
Yes.
You haven't?
No.
Yeah. And you mentioned Miss Baninzi,
Yes.
who was one of your pupils, and which you assisted with unopposed motions and so on at the beginning. Are you aware that she subsequently left because of lack of work? And if so, did you not feel any obligation to assist? Or if she did discuss it with you?
When Ms. Baninzi indicated that she was going to leave the Grahamstown bar, I did go and see her and I asked her why she was going to leave. And she told me it was as a result of a combination of personal reasons and a desire to study further. She never told me it was as a result of lack of work.
Okay, thank you. Honorable Singh.
Thank you, Chief Justice. Just one question. Good afternoon, Ms. Beard.
Good afternoon.
I just want to pick up on Commissioner Slama's question and the objection by Nadell. One of the things they say, and I'll just quote, at the age of 39 years, she would be an asset for the future. What is your view on the appointment of young people to the bench? And should youth be a constraint? And if you think yes, why? And if no, why not?
I don't think youth should in and of itself be a constraint. People are all different. Different people may reach a stage where they are ready to be considered for judicial appointment at different stages, time-wise, of their careers. I don't believe that youth by itself should be an impediment. It can be such that young people should be appointed to the bench so as to enable them sufficient time to develop fully to one day looking to appoint them to the apex courts. So no, I don't think youth should be an impediment.
Thank you, Chief Justice.
Thank you, Honorable Singh. If it be any comfort to you, Ms. Beard, I was 36 when I was appointed to the bench. President Maya?
And I was even younger, CJ, so. Good afternoon, Council.
Good afternoon, President Meyer.
The Supreme Court of Appeal did indeed uphold your decision in Kola on the very principle which was raised with you by Commissioner Norman. And it was held that a judgment debtor cannot avoid execution against his immovable property where he does not make the movable assets he claims are available, for execution available to the sheriff. So you get a tick there.
Thank you.
But my question to you is actually a follow-up on what the Premier asked you about your failure to apply to Umtata, which is my hometown, when you have applied to the rest of the seats of that division. And I ask this because I'm sensitive. I know that people avoid Umtata because it's a rural area and it's considered far from civilization. I think I have a right to ask the question because I work in Bloemfontein and my home is in Umtata. And 99.9% of my colleagues at the SCA do not live in Bloemfontein. Some live as far away as Cape Town, but somehow we make it work. What is your real objection to Umtata? And what would prevent you from traveling on weekends between Grahamstown and there, as you would if you were in PE or Bisho?
My real and genuine reason is because of the commute. It is a 4-hour drive between Umtata and Grahamstown. My objection is certainly not to Umtata itself. I have acted in Umtata and I did enjoy my time there. It really is the commute. Makhanda, Grahamstown is equidistant between Bisho and Port Elizabeth. They are simply closer to home.
Do you have younger children, maybe?
I don't, but I do have family in East London. So if the Commission were to ask me, my first choice, it would be the Grahamstown High Court, then the Bisho High Court, and then Port Elizabeth.
I was just asking because I travel 4 hours every weekend to go home in Mafikeng, but maybe there are different considerations. Honorable Magwanisha?
Thank you, Chief Justice. Good afternoon, Advocate.
Good afternoon, Commissioner.
Do you agree with a view that says we need to develop our African legal jurisprudence? And how has that found expression in your judgments?
Yes, African jurisprudence should be developed. There are judgments developing customary law. It is a very important source of law, and the Constitution mandates that it be applied where it is applicable, subject only to the Constitution itself and any legislation dealing specifically with customary law. So yes, customary law must be developed. Unfortunately, in my time acting, I have not had the opportunity of dealing with customary law. As a judge, you can only deal with the matters that come before you, and I haven't had a matter come before me involving customary law.
Commissioner Nkosi Thomas?
Time flies. Good day, Ms. Baird.
Good day, Commissioner Thomas.
You know, it just emerged now that your mentee, if I may refer to her as such, Ms. Baninzi Baninzi has left the bar, and you say to us that the reason for her leaving the bar is because she wanted to study further. But it's very unusual, I can tell you that for a fact, to say black female counsel for a black junior with a thriving practice to simply abandon ship and go pursue other things. So sitting where I'm seated now, the only reasonable inference to be drawn from her having left the bar is because she was starved of work. But I'm not going to blame you for that. Mine is simply to invite you, if I may, to comment on two comments from law bodies, one from Nadell and another one from the Society of Law Teachers of South Africa. They both flag the issue around transformation, and they invite us to probe your transformation credentials. So I'm merely affording you an opportunity to persuade us whether or not you've been active in this space. If you may, please.
Certainly. I have had two black pupils, as I have mentioned. And so I have been engaged in skills transfer on that level, which I believe is supportive of transformation and transformation of the bar in particular. In addition to that, as I have mentioned, I have given deviling to all of the juniors at the bar, and I do so as frequently as I can in order to support them financially. I'm also involved in advocacy training. I am a trained advocacy trainer, and I have been involved in advocacy training in the past. I have been involved in advocacy training beyond simply the Grahamstown bar. I was involved in advocacy training at a stage when the Mthatha and the Transkei Mthatha and Bisho bars sent their pupils for training with the Eastern Cape Society of Advocates as well.
Thank you. My second question, please, if I may, Chief Justice. You see, you told us that upon a question from the Judge President Mlambo, he asked you, how did you get to build a commercial practice? And your answer, if I remember correctly, was that your mentor or your pupil master, as it were, they introduced you actively to attorneys in order to ensure that you build such a practice, and which is hence you command a practice of that sort. Now, the direct question is, have you done that for Ms. Baninzi, and if not, why not?
I'm sorry, I had thought that I had mentioned earlier that I actively introduced both Ms. Baninzi and Mr. Ntlokwana to the attorneys who do instruct me, and I thought that I had also mentioned that once they completed their pupillage, I reminded those attorneys that they had successfully completed their pupillage.
Thank you so much, Commissioner Ndgosi Thomas. JP Mbenenge.
Thank you very much, CJ. Maybe just to contextualize it and ensure that we don't get around this without me pointing it out. I would like to get your comments on this scenario that I'm going to present. We've got 38% female judges in the Eastern Cape. 13% African, 0% colored, 4% Indian, 21% white. Now, my question is simply this: does it really matter that we've got that scenario?
Judge President, it does matter. The total representation of women on our bench is below where it should be. And we are lagging behind in respect of non-white women on our bench. We are. It is something that should be addressed. it is important.
Thank you. Could I afford you the opportunity to retract the word non-white?
Certainly, my apologies.
Thank you.
Thank you. Just to get clarity, do you know why he asked you to retract it? Because sometimes we say things innocently without understanding, and the likelihood of repeating is vast. Do you understand why the JP asked you to retract?
I think I do. I'm sorry, I spoke without thinking, and I most certainly intended
Okay.
no offense.
Sure,
What I
sure,
wished to indicate was that the Eastern Cape bench is lagging behind in respect of representativity of colored Indian and
Yes.
black women, because in respect of all of the percentage representativity on our bench, those are the lowest.
No, I understand. I just wanted to assist if necessary in that regard. I know we sometimes speak without thinking. I've heard many women use he in circumstances where they should be saying he or she. So we all make mistakes. Thank you very much, Advocate. You're excused.
Thank you very much.
Thank
Thank you
you.
for your time.